much. Well, the U.S. Supreme Court today denied a request to review the cases of several Guantanamo Bay detainees fighting their treatment and their detention at Gitmo. The High Court sided with the Obama administration, refusing to review the cases filed by the prisoners. As you probably know by now, 169 prisoners are being held at Gitmo, including the terror suspects who claimed responsibility for the attacks of 9/11. Context and perspective now from our senior judicial analyst, Judge Andrew Napolitano.
Chip.
Explain me.
Well, at the tail end of the Bush administration in 2008, the Supreme Court of the United States ruled that the right to habeas corpus, the right to force the government to try you, reveal the evidence against you, or free you, applies to everyone, all persons, American and non-American, those who wish us well, those who wish us ill, and it applies to the people in Guantanamo Bay. And it ordered that the federal district court in Washington, D.C. hear these applications from Guantanamo Bay detainees, meaning the government had to reveal the evidence it had against them and how it got the evidence. So of 59 detainees who asked for these hearings, the court ordered 32 of them released and 27 of them kept in prison. None of the 32 has yet to be released. So they filed appeals to the Circuit Court of Appeals, which invalidated those release orders, and then they asked the Supreme Court to hear that appeal, and today the Supreme Court said no. So we are left with a terrific 2008 decision, which says that habeas corpus, basically, the government can't lock you up without evidence against you. Applies to everyone, no matter who they are and no matter where the government restrains them. And yet when the decision is applied, it doesn't work the way it's supposed to work because the person's ordered freed or still incarcerated.
Remember, after the attacks of 9/11, there was a widespread belief by many who are experts in these matters that we might have to change some of the rules in this nation.
Yes, there was.
And it sounds like what you're saying is, rather than changing the rules, we have decided without deciding to break the rules.
You know, Shep, there has been an age-old argument, and all lawyers and even law students and legal scholars and judges know this, about whether the rights protected by the Constitution protect all persons or just Americans. A lot of us who follow these things for a living thought that once and for all, that argument had been resolved in favor of it protects all persons. The language says persons. It doesn't say Americans. So you're right. On paper, this looks terrific. But in the practical application of it, the Supreme Court has allowed lower court federal judges to eviscerate, to destroy, to gut, to render useless this opinion. And darned if we know why.
So what's happening is, rather than following their rules, they're just releasing these people.
No, they're not.
Or in other cases, holding them forever without going through the process.
They're going through the process. A trial judge says this is not competent evidence. You cannot base a conviction on this evidence, so I'm going to order this person freed. The government appeals that, and the Intermediate Appeals Court says, well, we disagree. We think that evidence is competent. Then these people appeal it to the Supreme Court. The Supreme Court says, we're not going to hear the appeal. Bottom line, no one has been freed since that decision in 2008, except the person who brought that 2008 case. The others have been kept incarcerated, even when the judges who heard these cases said, you can't get a conviction based on this evidence.
And is there a word of what happens next? Do we just continue to hold people?
Well, theoretically, these people will get another shot at freedom when the government prosecutes them. Of course, we know how long that takes. The 9/11 people, had they been prosecuted in federal district court in New York, probably would have been executed by now. The military tribunal is yet to commence.
Wow.